In this video, I'll briefly cover the conditions that are imposed on intermediaries in order to rely on the benefits provided by the safe harbour system. As a threshold matter, to be eligible to rely on the safe harbours, all intermediaries must adopt and reasonably implement a provision for the termination of the accounts of repeat infringers on their networks. This is quite problematic, because for many intermediaries, it is not clear what this requirement actually entails. In particular, there's no accepted definition of who is a repeat infringer, or what appropriate circumstances might be that would necessitate terminating their access to the network. For some intermediaries, this is less problematic than others. It's more problematic, for example, for internet service providers who are providing access to users and subscribers to terminate them from their internet connection completely than it is from, say, a content host who has the ability to refuse to host the content on behalf of those users in the future. That's a less serious penalty than being removed from the internet entirely. The key condition I want to talk about today, though, is a condition imposed on Category C hosting and Category D indexing or search providers to remove content that is infringing on their networks. This is the notice and takedown provision. There are some threshold limitations on the Category C and D safe harbours. The first restriction on Category C hosting activity is that the intermediary must not receive a direct financial benefit from the infringing material, in circumstances where they have the right and ability to control. This applies in particular to negate the protection of the safe harbours where the intermediary derives a clear benefit from the material, from the infringing material that is uploaded. So, for example, to take an analogy from the facts of the Cooper case. In the Cooper case, the ISP who was providing hosting services benefited from the extra traffic that was generated by people coming to Cooper's website in order to find infringing MP3 files. That was a direct benefit that was attributable to the existing infringing files on the site. By contrast, there was an argument that was sought to be raised by the plaintiffs in the IINet litigation. And in that case, the plaintiffs suggested that IINet became directly profited from its users' infringements because infringement was one of the important things that users did with their internet connections. The court was much more hesitant to draw that direct line in the IINet case, because in IINet, it couldn't be directly said that infringing users are much more profitable than non-infringing users, and therefore the benefit that IINet receives is really just the benefit that everyone provides as a paying customer of their service. The second set of conditions are the notice and takedown provisions. So the first one arises when a carriage service provider becomes aware that there's infringing material on their network. If there are facts or circumstances through which the ISP should have been aware that the material is infringing, that means the ISP has an immediate obligation to remove that content if they want to rely on the safe harbour. Importantly though, service providers have no positive duty to actually monitor what content people upload to their networks. So this is when the notice part of the scheme becomes important. The other restriction is that when a service provider receives a notice in the prescribed form, that service provider must expeditiously act to remove the content from its network. The procedure for a notice and takedown is detailed in the copyright regulations. The regulations provide more detail about the information that is required to be present in a notice in the prescribed form and what the obligations of the online service provider are in responding to that notice. They also provide a counter notice scheme, where the service provider must provide notice to the user whose content it's removed, and the user has 3 months to lodge an objection to the removal of that content. This is designed as an attempt to protect the speech rights of individuals to host content that is not infringing by limiting the potential for abuse of the system. Once a service provider receives a counter notice from a user, it must immediately put the content back up, and then the copyright owner's only remedy is to go to court. Globally, notice and takedown is a massively important way in which states and private entities regulate the internet. Google, for example, currently receives about 32 million notices each month asking it to remove content either from its search engine or from its domains like YouTube. This is a massive project. In Australia though, notice and takedown plays a relatively small role because of the limited set of intermediaries who are actually eligible to apply for protection under the Safe Harbour scheme.